Good afternoon, everybody. My name's Edward Denehan, and it's my pleasure to welcome you to the final webinar in the series of webinars I've put together concerning the operation of Part 2 of the Landlord and Tenant Act 1954. Today's webinar concerns the statutory grounds of opposition, and we'll look at each of the grounds in turn and explore some of the elements that arise in their application. In the usual way with these webinars, I don't take questions during the webinar, but I'm very happy to address questions or other inquiries concerning the content of the webinar after the event. Please just send an email if you have any questions or doubts or points you wish to make about what I've said. Please note no specific cases, but just general points arising out of the webinar. In the usual way, I've prepared a substantive paper addressing in far more detail than I can speak to in the hour that we have together on the subject matter of today's webinar, the statutory grounds of opposition. In the next couple of days, delegates will receive an email with a link where they can download the paper and the PowerPoint slides for what that's worth. And in any event, at about the same time, the material will be available for downloading from our Chamber's website. But as I say, all delegates will receive an email with a link which they can download the material. So moving on, the statutory grounds of opposition are found in section 30 and in particular subsection 31. So when I say section 31 in this webinar, I'll be referring to section 30 subsection 1, and the grounds can be relied upon by a landlord to oppose an application by a tenant under section 24(1) for a new tenancy, and in support of an application by the landlord under section 29(2) for an order terminating the current tenancy. Those are the circumstances in which the grounds can be relied upon, and that's made clear from the opening words of section 31. As described in earlier webinars in this series, tenants make applications under section 24(1) for a new tenancy. Section 29 allows the landlord to take the initiative after relevant notices have been served by issuing proceedings under section 29 to bring the tenancy to an end. 29(2) is only available to a landlord if it has said that it's going to oppose the tenant's application on one of the statutory grounds. I want to make this point, and it's self-evident, but I make it nevertheless. The statutory grounds can't be relied upon to determine the current tenancy earlier than it would have come to an end at common law. So, for example, if there's a fixed term tenancy that expires at common law on the 24th of June 2023, nothing in section 30 or in the Act at all allows the landlord to determine the tenancy before the 24th of June 2023. Similarly, with periodic tenancies, which are somewhat unusual in my experience in relation to business premises, the landlord can't rely upon anything in section 30 to determine the tenancy any earlier than it could by serving a notice to quit on the tenant. The statutory grounds are simply a mechanism to frustrate, if you will, the tenant's statutory right to obtain a new tenancy. And it's entirely a matter for the landlord whether it wishes to rely upon the grounds and oppose or not. And as we discussed in earlier webinars, there's some important commercial decisions that have to be made by landlords and indeed tenants in that context. The statutory grounds must be engaged, and the landlord does this in one of two ways. If the landlord takes the initiative with the renewal procedure and serves a notice under section 25, the pro forma, prescribed form, forgive me, that must be used of the section 25 notice, it provides that the landlord must state whether it is going to oppose an application for a new tenancy, and if it does, specify the grounds upon which the landlord is going to rely. The second means by which the landlord can engage the grounds is when the tenant takes the initiative in the renewal procedure and serves a section 26 request. There's the ability of a landlord within 2 months of such a request being made to serve what's called a section 26(6) counter notice in the prescribed form, giving notice of its opposition if the landlord is opposing, and if it is opposing, specifying the grounds relied upon. And again, it's self-evident, but I'll say it nevertheless, that the only grounds that can be relied upon are the statutory grounds described in section 31. There may be jurisdictional issues arising out of the proceedings, but they're not concerned with the grounds of opposition prescribed in section 31. It's important that landlords who take the initiative under 25 or serve a counter notice under section 26(6) specify all those grounds that they want to rely upon, because one can't add to the grounds at a subsequent time. And as I say, if neither of these steps are taken by the landlord, then it cannot oppose the application by the tenant, and the tenant will get a tenancy of some sort. And the landlord can abandon the grounds later, but it can't add to them. It can't amend, as it were, the section 25 notice or the section 26(6) counter notice. Well, with those introductory words, let's get to the grounds themselves. And they're on the screen now, and they're found in paragraphs A to G of section 31, and they're failure to prepare and maintain, persistent delay in paying rent due, other breaches of obligations and other reasons, suitable alternative accommodation, current tenancy created by subletting of part, demolition and reconstruction, and finally, landlord's own occupation. Some of those bullet descriptions don't accurately describe the ground, for example, E, because it's just not capable of being summarized in a bullet point, but we'll come on to discuss the details of it in a few moments. The landlord who can rely upon the grounds of opposition is the section 44 landlord at the date of the hearing of the ground of opposition. The section 44 landlord may not be the tenant's immediate landlord if the immediate landlord's interest is shorter than 14 months. And I set out in the paper the definition of the section 44 landlord, but in the majority of cases, it will be the immediate landlord. It's accurate to say that the grounds A, B, and C are what are sometimes called bad tenant grounds. They are available to the landlord if the tenant is in breach of some obligation owed to the landlord, as we'll consider in a short while. The grounds in D, E, F, and G are available to the landlord irrespective of the conduct of the tenant. The tenant might be the acme of tenants, but the landlord can still successfully oppose an application under section 24(1) if the landlord satisfies grounds D, E, F, and G. And as we'll see, that the court has no discretion under, for example, F and G. If the landlord makes those out, then the tenant will not get a new tenancy. That's not the case in respect of A, B, and C, as we shall see. I'm bound to say that my own personal experience, professional experience, and the anecdotal evidence that I've been gathering in recent days from other barristers who pretend, like me, to practice in this area, is this: that grounds A, B, C, D, and E are very rarely relied upon. I can't ever remember doing a case under D and E, and we'll explain what those are in a minute. I can remember doing cases under A, B, and C, the bad tenant ground, but not for a long time and not very often. And the reason for that is, as I suggest, as follows: that the bad tenant grounds, breach of some obligation, if the landlord is faced with a tenant who's in breach of its obligations under the relevant lease, then the landlord, in the vast majority of cases, will have immediate remedies available to it. If the tenant doesn't pay its rent, the landlord can sue for the money and get it, or forfeit the lease if the relevant tenancy agreement or lease contains a proviso of free entry. Equally, if the tenant is in breach of its repairing obligations or in breach of some other obligations under the lease. Grounds D and E, alternative accommodation and the current tenancy created by a sublease, the circumstances when they arise are, I suggest, not very common, and therefore don't often arise. It's F and G, in particular ground F, that are the grounds which are more frequently relied upon when opposing an application under section 24(1). Start with ground A. Ground A is now on the screen. It's where, under the current tenancy, that's the tenant's current tenancy, the tenant has any obligations as respect the repair and maintenance of the holding. Pause there to emphasize it's the repair and maintenance of the holding, that the tenant ought not to be granted a new tenancy in view of the state of repair of the holding, being a state resulting from the tenant's failure to comply with the said obligation. As I say, the current tenancy is the tenant's tenancy, which qualifies for protection under Part 2 and would include the continuation of that tenancy under Part 2, under Section 24(1), as we've discussed in other webinars, that if a tenant has a fixed term tenancy that came to an end on, say, the 25th of March, 2023, and it was otherwise a tenancy to which Part 2 applies, Section 24 will continue the tenancy after the March quarter day of this year, and unless and until it's determined in accordance with the provisions of the Act. So the grounds are available even if the continuation period has arisen and the tenant fails to repair and maintain the holding during that period. Of course, it only arises if there are obligations in respect of repair and maintenance under the current tenancy, which may or may not be the case. Clearly, this is wide enough to accommodate express repairing obligations, be they internal, external, or both, and would also give rise to, would also cover implied obligations, for example, not to commit waste and so on and so forth, if that breach of implied obligation by the tenant can be properly said to impact on repair and maintenance of the holding. Again, as we say before, in just about every webinar concerning Part 2 of the 54 Act, the holding is defined in Section 23(3) of the Act, and that's part of the demise premises which is occupied by the tenant for the purposes of its business, or occupied by an employee in that business. So the classic example would be if the demise premises consist of a shop on the ground floor and a flat above, and the tenant occupies only the shop for the purposes of its business and the flat is empty, the shop will be the holding and the flat will not be, notwithstanding it's part of the demise premises. So when analysing whether ground A is made out, the court will be concerned with the state of repair and maintenance of the shop. and will ignore the state of the flat above. Seems somewhat odd that the landlord could let the flat run to rack and ruin, and that would have no consequence in the context of ground A. Might have under ground C, but we're not there yet. The word repairs is wide enough. It includes maintenance, decoration, or restoration, and reference to repairing, keeping, and yielding up in repair are construed accordingly. That's section 69(1) of the Act. The reference to maintenance of the holding extends the application of ground A, as there might be parts of the holding, a garden or yard or lift, which require maintenance rather than the repair. A failure to maintain a garden, which may be part of the holding, would engage ground A. And I cite in the notes the case of the London Borough of Wandsworth and Sing, where the demised premises were a garden, the holding was a garden. So in that case, if the tenant hadn't maintained the garden, the landlord could have relied upon ground A. Moving on, the holding. We've discussed what the holding is. There must be a failure on the part of the tenant to comply with its obligations, and that has an impact on the physical condition of the premises. There is authority to support the proposition that the consequences of the tenant's breach of repairing and maintenance obligations must be such as to have a substantial impact on the landlord's on the holding. The minor breaches will not be sufficient to establish this ground, even though the word substantial is not found in ground A itself. In a number of cases, I give some examples in the paper. It's been held, for example, the removal of ivy from a wall of a building was not a substantial breach of repairing and maintenance obligation, which gave rise to the ground A being relied upon. Even if the ground is made out, the court has a discretion. That's clear from the words, the tenant ought not to be granted a new tenancy. So even if the landlord establishes that the tenant has been in breach, the court can retain, it has a discretion, or must make a value judgment, as said in one case, to decide whether the tenant ought not to have a new tenancy. The converse of that is that they ought to have a new tenancy, and the court can look at all the circumstances. The way I test this is, we're now in a position where the tenant is asking the court, I want a new tenancy. I want to establish an ongoing relationship for a number of years with the landlord. And the landlord says, well, the tenant has been in breach of its obligations, and therefore I'm opposing. The court will take a step back and say, would it be fair and right in all the circumstances to burden the landlord, to foister upon the landlord a tenant who has historically shown itself to be a tenant who will not comply with its obligations under the new lease? The factors obviously will be the substantial nature of the breaches. They've got to be substantial, which means something more than just above de minimis. There's no requirement that there be extant wants of repair at the date of the hearing. The court can look back at the history of the tenant's breaches of obligation. Clearly, if it's been ongoing throughout the term of the current tenancy, that will be a factor. Might also be a factor if the tenant, for example, has been in occupation of the demised premises for a substantial period of time, or if not that particular tenant, but the tenant's predecessors to the business. If the business has been established in the premises for a long time, there might be more room for forgiving the tenant's failure to comply with its obligations. As it's said on the screen now, the landlord must satisfy ground A at the date of the hearing, and I refer throughout the notes to this well-known case back in the 60s in the House of Lords, Betty's Cafe Limited and Phillips Furnishing Stores Limited, which establishes that the grounds of opposition have got to be established at the date of the hearing being the hearing of whether the grounds of opposition is made out. And if that is heard as a preliminary point, which will inevitably be the case, as we discussed in the previous webinar, then that's the relevant date. I say Betty's Cafe support that proposition, which has this consequence, that the landlord doesn't have to establish that at the date it served its Section 25 notice or Section 26.6 counter notice that there were breaches of the repairing and maintenance obligations then. Now, it would be an odd situation, I suggest, where the tenant had been entirely compliant with its obligations to repair and maintain, and yet the landlord still served a Section 25 notice or Section 26.6 counter notice saying that it hadn't been. I've done cases, they don't often arise, where the landlords just specify all the grounds in the Section 25 notice, a sort of shotgun or scattergun approach, but that's rare. But it doesn't matter. It's at the date of the hearing, and that's why success is entitled to the landlord who served the notice can rely upon that notice if at the date of the hearing they can establish there were breach and the tenant ought not to be granted a new tenancy. Ground B is that the tenant ought not to be granted a new tenancy in view of his persistent delay in paying rent which has become due. It's rent properly so called, and other sums reserved as rent that are caught by ground B, but not sums payable under the current tenancy generally. So if for example, service charges are not reserved as rent, then the persistent delay in paying those sums cannot be relied upon by the landlord in support of its ground B. There's no specific period of delay in paying or no specific amount that has to be outstanding in order to engage ground B. As delegates will be well aware that, for example, under forfeiture clauses, it's often said that if the rent is arrears of 14 or in other cases 21 days, then the landlord can forfeit. Nothing like that under ground B. There doesn't have to be a specific amount of money, X pounds or 3/4 or anything of that delay. And indeed, there doesn't have to be any arrears at the date of the hearing. And what there must be is persistent delay. So the odd late payment will probably not get the landlord past the post when it comes to ground B. But again, the court will look back and say, has there been a persistent delay in paying rent? Does this landlord have to keep chasing the tenant for the rent, sending dunning letters? Was said in one of the cases I remember relying upon a number of years ago. And if so, then it's not going to be fair in all the circumstances of the case to burden the landlord with this delinquent tenant going forward. So even if the tenant has paid every penny of rent due by the date of the hearing, that doesn't necessarily prevent the landlord from succeeding under ground B. And as I say, ground B ought not to. And the question I ask, is it fair in all the circumstances for the delinquent tenant to be foisted on the landlord going forward? And if the answer to that is no, then the ground will be made out. Ground C is a sort of, in one sense, a catch-all. It's split into two elements. Let's read it first. The tenant ought not to be granted a new tenancy in view of other substantial breaches by him of his obligations under the current tenancy, or for any other reason connected with the tenant's use or management of the holding. So I say there's two discrete parts there. Other substantial breaches by the tenant of its obligation, and the second element is concerned with any other reason connected with the use and management. The reference to other substantial breaches makes it clear, I suggest, that ground C is concerned with obligations that are not repair and maintenance and payment of rent. So that could be, for example, non-payment of a service charge or some other and provided those obligations arise under the current tenancy, it doesn't matter how those obligations arise. A single breach of covenant can be relied upon, or breach of obligation can be relied upon on ground C, provided it is substantial. And again, that means something more than de minimis. I produce a list in the paper of what has been held to be substantial breaches of covenant. I'll give you a flavour: making structural changes to the demised premises without the landlord's consent, sharing occupation contrary to alienation provision, illegally burning waste in breach of an obligation to comply with all laws, and failure to ensure the demised premises. You'll note that in ground C, unlike grounds A and B, there's no mention of the holding. So here we're concerned with breaches of obligations that impact on the demised premises as a whole and need not be limited to breaches of obligation that impact on the holding. The second part, ground C, is concerned with the use and management. And in this Turner Bell against Searless case, it was said that entitled the court to look at everything which the court thinks is relevant in connection with the tenant's use and management of holding, past, present, or future, which may enable the court to fairly exercise its discretion under that section. Well, I don't suppose that one can look into the future unless there's something in the past that suggests the future conduct of the tenant might be unacceptable. There's an interesting example of successful reliance upon the second element in ground C in the case of Horn and Meredith Properties, which I set out in the notes. And essentially what happened there was that the poor landlords were in a relationship with two, should I say it, lunatic tenants who over the course of a number of years commenced spurious court proceedings against the landlord, some of which were struck out because of the Henderson. They were just entirely misconceived, running up enormous bills which they never paid, and they had civil restraint orders against them. And the landlord relied upon ground C and said the conduct of the tenant is an example of their use and management of the holding, and their use and management of the holding involved a war of attrition against the landlord based upon allegations which were without any substance. The court again has a discretion under C, ought not to, and may look at all the circumstances. And again, good old Betty's Cafe case supports the proposition that the ground of opposition has to be made out at the date of the hearing. So those are the bad tenant grounds. We now seamlessly slip into those grounds which are available to the landlord, irrespective of the conduct of the tenants. And the first of those is ground D. And this is suitable alternative accommodation. And it is that the landlord has offered and is willing to provide or secure, note there, provide or secure, the provision of alternative accommodation for the tenant, that the terms on which the alternative accommodation is available are reasonable, having regard to the terms of the current tenancy and to all relevant circumstances, and that the accommodation at the time at which it will be available are suitable for the tenant's requirements, including the requirement to preserve goodwill, having regard to the nature and class of its business and to the situation and extent of and facilities afforded by the holding. The landlord, again, is a section 44 landlord who may not be the tenant's immediate landlord. and I've described in the notes who that person is, as I've previously said. There are three elements in ground D: an offer by the landlord of accommodation which it's willing to provide or secure. It must be on terms that are reasonable, and the accommodation and the time it is made available must be suitable. I suggest that procure and secure mean different things, otherwise they would not have been, those words would not have been used. I suggest that provide means, for example, the landlord saying, well, you occupy the third floor of my office building as a office accommodation for your business. I'm offering you alternative accommodation on the fourth floor. So the landlord provides a new tenancy of, or new accommodation of property that he or she, the landlord, owns. Secure, I think, means something different. In the context of the Rent Act, where one of the grounds of possession is the provision of suitable alternative accommodation, it doesn't have to be provided by the landlord. So, for example, if the landlord can say, well, I can procure a new tenancy of a shop down the road, which is owned by the Crown Estates, and all other criteria in ground D are satisfied, then that would be sufficient. In that sense, if you will, it is as if the landlord is acting as a property agent trying to find new accommodation for the tenant. The terms must be reasonable, and that's an objective assessment, but of course we are obliged to have regard to the terms of the current tenancy and to all relevant circumstances. The words having regard to the terms of the current tenancy and to all other relevant circumstances are also to be found in section 35. Section 35 of the Act makes provisions for the terms of the new tenancy, or a new tenancy, other than duration and rent. And so the starting point in the context of ground D, as it is under section 35, is that one looks at the terms of the current tenancy, and if what's being offered in terms of the terms on which the tenant will occupy the offered accommodation are not comparable, I go as far as to say that, then it's unlikely that ground D will be made out. Of course, it may well be that it's an impossibility for the landlord to get alternative accommodation or provide alternative accommodation and precisely the same terms. There might be slightly different premises and so on and so forth. But in my view, the main terms of the tenancy of the offered accommodation must be pretty close to the terms of the current tenancy, and the burden will be on the landlord to justify any departure from the terms of the current tenancy. Self-evidently, if the rent is greater, that's unlikely to find favour, even if the premises are, in inverted commas, better, bigger, for example. The tenant's happy in its current premises, doesn't want bigger premises at greater rent. If some other financial burden is placed or increased upon the tenant, increased service charges, for example, different regime for the collection of service charges, as in the OMA case, then that's unlikely to find favour. Clearly, it's got to be premises that are suitable for the tenant to continue its business carried on in the holding demise by the current tenancy. There's no point. It's a ridiculous example of a shop trader being offered alternative accommodation on the first floor of a block of offices. So that's what it's got to be offered. The offered accommodation must preserve goodwill. That's rather a tricky concept, because for those of us who are not in the property dealing business, goodwill attaches adheres to the premises. So I've been carrying on my business at Limestone Buildings for what it's worth, for how many years it is now. And so there's a goodwill attaching to me being in these premises. Now, if I've got to go somewhere else, it's not a very good example, But what I suggest is that what it means, goodwill means in this context, is that the tenant who, for example, is a high-class retailer in the West End of London or in Knightsbridge, he can't be offered a retail premises in some less, or on another part of the world I know very well, Camden High Street. That doesn't fit because no goodwill would attach, even if all the terms of the tenancy and the premises themselves were suitable, because the citizens and denizens of Knightsbridge and the West End do not do their shopping, I would suggest, in Camden Market. So that's ground E. There's not much utility, I suggest, exploring this any further in the abstract. One has to know what the offered accommodation is to compare it to what the tenant has at the moment. And as I say, ground E is not often relied upon, and therefore I think it's we can move on without spending too much more time on that. Now, this is ground E. I'm not going to read that out because I'll just bumble and stumble. Indeed, in the Betty's Cafe case, counsel submitted to their lordships that ground E was unintelligible, and certainly Viscount Simmons didn't demur from that. But what I've done to try and make it more palatable for me, quite apart from anybody else, is to deconstruct it in this way. And in this way, you'll clearly understand why it is ground E is not often available. There must be a head tenancy of property. Part of the property must be sublet. The sublet premises must be under a tenancy to which Part 2 applies. The head landlord must be the Section 44 landlord. So pause there for a second. I've got a tenancy of a block of offices with 3 floors in it, and I sublet 1 floor to T, the tenant, and T occupies that 1 floor for the purposes of its business, and it's a tenancy within Part 2. That's 1, 2, and 3 satisfied. But if I'm the Section 44 landlord, namely the tenant's immediate landlord, could be if I've got a substantial interest remaining in the premises, then ground E is not available. It must be my landlord, the landlord under the superior tenancy, who is the Section 44 landlord. So that means that my tenancy must be coming to an end within 14 months. That's a paraphrase of how Section 44 wants. So if that's the case, and already we're losing the will to live, that Section 44 landlord must go on to prove that the aggregates of rent reasonably obtainable on a separate letting of the holding and the remainder of the property. So now we're concerning the holding is the sublet part, and the remainder of the property is the rest of the property that's been let, would be substantially less than the rent reasonably obtainable on a letting of the property as a whole. So in my example, if the head landlord can get more for his 3 floors of offices than he can get for 2 and 1 floor of offices in terms of rent, then 5 is satisfied. And on the termination of the current tenancy, the landlord requires possession of the holding for the purposes of letting or otherwise disposing of the whole of the property. So even if those first 5 elements are satisfied, it's not a hypothetical or a paper analysis. The Section 44 superior landlord must say, well, if I get this back, I'm actually going to let it and get those higher rents, or I'm otherwise going to dispose of the property by myself, selling that person's interest, the freehold, for example. So one can see there that the ground is very rarely going to be available to the Section 44 landlord. Again, there's a discretion, ought not to be granted a new tenancy. It's hard to understand how that exercise is exercised, if you will, against a tenant, or in the context of ground E, because the tenant's done nothing wrong. When one had under A, B, and C delinquent tenants, one can see that, well, I can say, well, they're a bad tenant. I don't want to, says the court, I don't want the landlord to be stuck with them. Even in ground D, tenant's been unreasonable for refusing the shop next door or the office on the floor above. But here the tenant, I repeat, has done nothing wrong. I think the best analysis is that the tenant simply, the analysis is that the court will simply take a step back, and in the overall scheme of things, decide whether it's right that the tenant be required to move. Again, if, for example, the tenant's business has been carried on the premises for a great number of years, that might be a reason for not allowing the landlord to rely on ground E. If the landlord is a recent purchaser who just wants to turn this property and make a buck, then that clearly would also be a relevant consideration. But thankfully, ground E is very rarely encountered in practice. Ground F, now we're getting to the meat of it, and this will be familiar to the delegates. On the termination of the current tenancy, the landlord intends to demolish or reconstruct the premises comprised in the holding or a substantial part of those premises, or to carry out substantial work of construction on the holding or part thereof, and that he could not reasonably do so without obtaining possession of the holding. You'll see there that what we're concerned with is demolition and reconstruction of the premises that comprise in the holding. So again, limited to those parts of the demise premises which are occupied by the tenant for business purposes, which may or may not be the entirety of the demise premises. In the last 4 years, there's been a shift in the application of this ground arising from the decision of the Supreme Court in the Francis Limited and Cavendish Hotel, 2019. Very rare for the Part 2 to reach the House of Lords or the Supreme Court, and this is the first case that's reached the Supreme Court, the highest court in the Supreme Court era, and it concerns the what this meant by the landlord intends. I analysed the Francis case at some considerable length of the note, and of course I won't speak to that today. But the general orthodoxy based upon old authorities was this, that if the landlord could satisfy the court that it had a genuine intention, settled intention to carry out the works, whatever they might be, and we'll talk about that in a second, and could satisfy the court that the landlord had practical ability to bring those events about, the works about, then that would be sufficient to establish intention. So the first question was, Mr. Landlord, Miss Landlord, do you genuinely intend to carry out the proposed works? Yes, that's a subjective question. 2, have you the practical means to bring about those works, which is objective. The court looks at all the circumstances, say whether the landlord can or can't. A landlord might want to redevelop his block of flats into a nuclear power station. They might genuinely want to do that, but self-evidently, silly example, but self-evidently that's never going to come around because you never get consent for a nuclear power station in a business park outside Rickmansworth or whatever it might be. Now, the Cavendish Hotel case, the Francis case, turned that on its head somewhat, because what happened in that case is that the landlord, that's the hotel, opposed the application for a new tenancy by the tenant, Francis Limited, who sold high-end rugs and so on and so forth in Mayfair. That's where the premises were, in a shop within the hotel grounds. And the scheme of works which the landlord put in place were designed for the sole purpose of satisfying ground F. And again, I explained in the detail how they manipulated the works in order to, for example, avoid having to apply for planning permission. And the landlord's witness went in the witness box, and she was praised for being an honest and candid witness. And she said, yes, we're doing this solely to get the tenant out. And all it went to Supreme Court on that issue, because historically, I've advised many times that, and so have others who do what I do, that the motive of the landlord for doing the works is neither here nor there. If there are works within the Section 31F, and the landlord intends to do them in the manner that I've just described, those two elements, then that's the end of the game. One didn't have to look any further than that. And indeed, I and others who do what I do have, from time to time, asked to advise what's the minimum work the landlord has to do in order to get ground F off the ground. And yeah, that's what we've had to do. It was all revisited in the Francis case. And essentially what it said was that the acid test is this, that if the landlord would not carry out the works if it got vacant possession, for example, if the tenant just upped sticks and left, then that's not a sufficient intention for the purposes of section 31F. And again, in the Cavendish case, the landlord's witness candidly said, if the tenant were to leave after we served our section 25 notice, we wouldn't do these works. But they didn't. So we generally will carry out these works, and they were costing £350,000 odd. We will do the works, but merely to get them out. And then afterwards, we'll decide what we want to do with the premises. Essentially wanted to incorporate them back into the hotel in some way. So that's was a sea change brought about by the Francis case. And I repeat, I've set it out in great length in the notes. So now the way forward when it comes to intention is simply not the two subjective objective, namely, does the landlord have a bona fide intention, but two, does the landlord have the practical means of bringing it about? But there's this third element. Would the landlord carry out the planned work if the tenant had vacated the holding? And if the answer to that question is no, then ground F is not going to be available to the landlord. Now, it was accepted in the Francis case in debate among council and the Supreme Court judges that, well, that's just going to mean that landlords and their agents are simply going to tell lies, unlike the witness in the Francis case who told the truth. And Lord Sumption, who gave the leading judgment, said, well, we work on the basis that witnesses will all tell the truth, and those who don't will be found out by the judge. Yep. And Lord Briggs, in the same case, said he acknowledged that by adding this third layer to the requirement of intention, is likely to lead to an increased complication in the context of section 31F grounds of opposition. But he said that that was just an inevitable consequence of the true construction of that sub paragraph. So it's well worth reading. I might suggest the detail of the Francis case, which I've set out in the note. It is fundamentally important in the context of 31F, which, as I've mentioned, is the most common ground relied upon by landlords to oppose applications for new tenancies. Proof of intention. Putting it very simply, the landlord must adduce credible evidence that it has a bona fide intention to carry out the works, and often it's very difficult for a tenant to second guess that. If the proposal is without any utility at all, that might be a means of attacking the landlord's bona fide. It cannot be serious that you've got intention to waste money doing this when it's to no effect. But otherwise, it's very difficult to attack the landlord on the bona fides of its intention, the subjective analysis. A more fruitful area of debate in these cases is the second element, namely, is there a reasonable prospect of the landlord bringing about that which it intends, namely, can it implement the works? And that will involve, again, evidence. If it's an individual landlord, he or she will, or its agents, will give evidence to the effect that, yes, we've got planning permission to turn the office into a shop or office into a flat or whatever it might be. We've got the money to do it, or we can borrow the money. We've got a line of credit from Shyster Bank. We've got building contractors lined up, or we've got a good relationship with building contractor A, and so he or she will be available. All the plans specifications are available. Of course, depending upon what the works are, depending upon how much detail we'll have to go into. Back in the day when I started doing these cases, and the landlord needed planning permission in order to implement the scheme of works, the better view was you didn't get going under ground F unless you had the planning permission. That heresy, if that's the right way to describe it, was put to bed somewhat in the Gatwick Parking Services case, decided, I think it's in the late 90s, no, 2000s, no, arguing the late 90s, 1990s, where the tenant occupied fields, I think it was, as car parking, Gatwick Parking Services Limited, the landlord wanted to use the premises as a car park itself. The planning permission for car parking had a condition of personality, namely the Sargent family. The landlord didn't have planning permission at the date of the hearing, but adduced planning expert evidence to the effect that it was very likely that planning permission would be granted for Gatwick Park Services Limited to carry out car parking activities on the demised premises. The trial judge rejected that, and the Court of Appeal said he was wrong to do so. And the important point to derive from the Gatwick Parking Services case is that the landlord didn't have to show, or doesn't have to show, on a balance of probabilities that it will obtain planning permission, listed building consent, building regulation approval, whatever it might be, whatever consents might be. It doesn't have to prove on a balance of probabilities, just that there's a prospect of that being achieved, namely, it's not a fanciful proposition that the consents will be advanced. As was said by Lord Justice Laws in the Gatwick Parking case, the hurdle is not a very high one. So again, since the 20s, the early noughties, I've been relying upon the Gatwick Parking Services case to support that proposition, and therefore it's not necessary to go to court with your planning permission in hand. Of course, that's far better if planning permission is needed. And this the reliance upon ground F takes one back to the earlier webinars where we've been speaking about the tactics of initiating the renewal procedure. Does one go fast? Does one go slow? The landlord's got to prove his intention at the date of the hearing, the Betty's Cafe case. So it's got to be right. It's got to have its evidence, its ducks in a row at that time. Might be in the interest of the tenant to speed along, might be in the interest of the landlord to delay. So serving, if the landlord wants to rely upon ground F, the date of service of the Section 25 notice is an important consideration. If, for example, lots has to be done in order to tick all the boxes to be able to prove that there's a reasonable prospect of bringing about that plan works. As I say, the date that the intention must be shown is the date of the hearing. And of course, now we've got the third element of intention. Francis, I can imagine the landlord being, you wouldn't do this work only because you want vacant possession. Oh no, I wouldn't. So I don't know how far that's going to take one in the real world in these cases, but I suspect, well, I know from personal and anecdotal evidence that since the Francis cases, tenants for counsel for tenants are taking the Francis point and teasing landlords as to their genuineness of their intention. There are six types of work accommodated by ground F. It's not any kind of work. Demolition of the premises and the holding, demolition of a substantial part of those premises, reconstruction of the premises, reconstruction of a substantial part, substantial work of construction on the holding, substantial work of construction on part of the holding. Demolition involves some sort of destruction. Reconstruction means knocking something down and rebuilding it. There's no definition of construction, but there are certain guidance and the learned authors of Reynolds and Clark on renewal of business tenancy give a nice list of works that may or may not fall within the Act, the ground. I won't read those out now, but they're listed in the paper. So if the landlord simply wants to redecorate and replace the bathroom fittings, ground F is not going to get off the ground, I'm afraid. And as I said earlier, that in the past, probably not so much these days, one has had to advise, is knocking down this wall, is moving this staircase going to be enough to get me within ground F? And so it's substantial grounds. I did a case a number of years ago involving a Chinese restaurant in Soho. I was acting for the landlord, and I must confess, I thought that the works were little more than decoration and reconfiguration, but I managed to scrape by. My expert was very good. So it's major work, essentially, not just tidying up. Done all that. Timing of the works. Well, the ground says that on the termination of the current tenancy, the landlord intends to do the works. I'm paraphrasing. But what that means in reality, and of course it depends upon the nature of the works, it's within a reasonable time of the current termination of the current tenancy. As we've discussed, the current tenancy will finish 3 months and 21 days after the hearing is completed. The landlord doesn't have to show that on the stroke of midnight after that period, the builders go in or anything like that. He's got a reasonable time, or it's got a reasonable time within which to get things ready, if you will, for the carrying out of the works. And there must be a need for possession of the holding. The landlord can get in there and do the works because it's a right, he's got a right to do so under the current tenancy, then ground F will be made out. I must confess, I've always found it slightly surreal to think that a landlord who really wants to get back to the premises, reconfigure them and let them for a higher rent or sell them, would expend capital money doing works with the tenant still in there. I suppose the rent might increase under the new tenancy, so that really doesn't arise. Section 31A is a qualification to ground F. What that says is that ground F will not be made out if the tenant under the new tenancy will agree the landlord can come in and do the works without its occupation being substantially interfered with. Again, it's slightly surreal because no tenant wants that, no landlord wants it either. The landlord can't get VP, he's not going to do the work, so it's game over. I think I came across one case where the landlord, there was a dispute, landlord sought to rely upon 31F, tenant said, well, you can come in and do the works under my new tenancy with a suitable clause inserted, and the issue was whether the tenant's business would be substantially interfered with, which is a criteria under section 31A. My recollection, it was the installation of central heating. I can't remember what the outcome was, but it very rarely arises. Right, the last ground is G, that on the termination of the current tenancy, the landlord intends to occupy the holding for the purposes or partly for the purposes of a business carried on by him or as his residence. This is the second most common ground relied upon in my experience. Again, it has a number of elements which we've touched upon before. The landlord's intention, everything I've said about the Francis case and the 3 questions that have to be asked apply here. Does the landlord genuinely intend to occupy for business purposes or as a residence? If he says, I do, is there a realistic possibility of him actually occupying for business purposes? Doesn't have to be the same business, so if you need planning permission, same sort of debate. And is the landlord only relying upon this to get rid of the tenant, and he wouldn't occupy the premises if the tenant just left? That's the Francis element of intention that must be satisfied. So all that is familiar stuff. What's occupation? The landlord's occupation is the same as it is under section 23. You've got to have physical control of the premises and the physical presence. We discussed that in an earlier webinar. The landlord's business, it's trade, profession or employment, and any activity carried on by a body, corporate, body of persons, whether corporate or incorporate. It's quite interesting. It's called the purposes of a business carried on by him. It's not the landlord's business, it's just the business. And I've done a number of cases back in the days, these days, but where the landlord, for example, wants to carry on a business in restaurant premises, and it's exactly the same business as the current tenant. And you can imagine the heat that's generated in those cases, because the tenant thinks, well, I've built up my restaurant business. And I remember one case, an Indian restaurant in Southend. I've built up this Indian restaurant business in these premises, and now my landlord wants to essentially take my business and reap the rewards of all of that. Well, I'm afraid that's just how the ground operates. And there's a Humber Oil Terminals case decided in 2011, which is a modern affirmation that that is the case. And I repeat that the current tenant tends to get rather hot and bothered about that. The only solace, and it's not much, is that, of course, if a ground G is successfully made out, then the tenant will be entitled to compensation under Section 37, which will be the rateable value or twice the rateable value, depending upon how long the tenant has been in occupation, or how long the business has been carried on the premises. If it's 14 years immediately before the date of termination, then it's twice the rateable value. As for residents, my view is that a body corporate can't reside anywhere. So that's not available to corporate landlords. And what is residence for these purposes? There's not much authority on the point, but the landlord must prove that she is going to physically reside in the premises. Questions arise whether one can have two homes and so on and so forth, but I can't remember doing a case where the landlord on the G has sought to rely upon an intention to reside in the premises. The date of the intended occupation by the landlord, again, that's within a reasonable, although it says termination of the current tenancy, and that's the date specified in Section 25 notice or Section 26 Section 26 request, not the actual date. The landlord has a reasonable time. It doesn't have to move in the moment the tenant moves out. What's a reasonable time depends upon what the landlord is going to do in the premises. If, for example, it's reconfiguring office accommodation for its business needs, then clearly that would take some time, albeit that occupation for fitting out is business occupation for these purposes. See the Bakayoko case. Nothing in ground G provides that the landlord's got to stay in occupation for any amount of time. In one case, it was said it might be a short time, but it must not be fleeting or illusory. And that comes back, if you will, these are old authorities, come back to the Francis case, namely, am I only doing this to satisfy ground G in order to rid myself of the tenant? The last element is the 5-year bar, and it's quite involved, but put simply, if the interest of the landlord has been created or purchased within 5 years of the date of termination specified in the Section 25 notice or the Section 26 request, ground G is not available. So that prevents speculators buying up reversions and then immediately seeking to oppose applications under Part 2 on ground G. And as I say, I've canvassed in the paper what created or purchased means, and the detail is there. That's now the end of the paper. I've got a little long. I do apologize for that. But I was having so much fun. And I thank you very much for your attendance this afternoon. And for those of you who've attended the other webinars, I repeat, the material will be available to you in short time. In the next few weeks, I'll be putting together the next series. I might invite you to do this. If anybody has a particular interest that in property law that they would like me to address, then I'm always open to suggestions. And subject to that, I wish you a good afternoon and thank you.